theft of property, lost, mislaid, or delivered by mistake. 2C20-6. Okay, we're all familiar with the statement, finders, keepers, losers, weepers. So when is that statement untrue? It's untrue for a person who knowingly receives property that is delivered to him by mistake, or is lost, or is mislaid. He knows it's delivered by mistake and it isn't his, and he converts it to his own use. Then he's the weeper, not the loser. Okay? So that's the interesting part of this little law. This is part of the theft group of statutes created by the legislature. All the common law larceny explanations I gave before in my previous video on theft of movable property and theft of goods from merchants under the shoplifting statute, all the same theory. Concept is, for example, suppose someone delivered by mail to you, a valuable coin that was purchased from a gold dealer. And it was clearly intended for your neighbor, had his name and address on it, but they just stuck it in your mailbox by mistake. You know it, but you keep it. That's theft under 2C20-6. Now, what's your exposure if you're convicted? Well, this has to do with the retail value of the goods at issue. So under $200, it's a disorderly person's offense, punishable by a fine of up to $1,000, possible jail up to 6 months, criminal record for disorderly person's offense. If it's valued between more than 200 or less than 500, it's a fourth-degree crime. It's a felony. Possible imposition of a monetary fine up to $10,000. Possible jail up to 18 months. Felony criminal record. If the value of the goods is in excess of $500 but less than $75,000, you're looking at a third-degree crime, which is punishable by a fine of up to $15,000. Possible jail up to 5 years and felony criminal record. If it's worth more than $75,000, it's a second-degree crime. There's a presumption of incarceration. Monetary fines can be up to $150,000. Minimum 5 years, maximum 10 years prison. And of course, felony record. Now, with all these things, if you're convicted, you have to make restitution to the victim, meaning you have to give back the item or give the reasonable value of the item to the victim. Now, Mr. Gravatt, if we retain you, what can you do for us? Well, whatever it is, I can make it a lot less bad, probably. This is a rather unusual kind of theft case. I've not dealt with many of them, but I've dealt with all the other 2C20 cases, like theft of movable property, theft by deception, receiving stolen property. They're all graded on the same basis, meaning the value of the goods at issue or what basically sets the punishment. Oftentimes I can get these things downgraded. I might even be able to get it dismissed if it's clear that you didn't intend to steal anything, and that's always an open question in these cases. My name is Stephen A. Gravatt. My telephone number is 732. Please give me a call if you've been charged with this. It can be serious, and I can very likely help you a great deal. Thank you.